Judge, today's time day for sentencing in this matter. Let's see, I met with Zach a couple days ago. We went over the pre-sentence report. There, as far as I know, no additions or corrections to be made. I would just ask that the court have some considerations as the fines and costs, because my client is indigent.
All right. Are these the only things he's locked up on, or?
I have circuit court to deal with, but they're giving me a year with 8 months credit, I believe, if I'm correct, with Judge Patrick Collins Jr. And I just have
He's got to also complete the Dawn Farm program.
Yes, that's perfect.
Which he hasn't started yet, so it's going to be a little bit.
And Teresa Blair on behalf of probation, Your Honor, it's my understanding from the circuit court appeal that is correct, that they are recommending, he has a violation of probation hearing, I believe that's on June 12th, that they are recommending the year. However, he does have a large credit. Mr. Burlett did ask in this case, I mean, this is a year-long case, he wouldn't have that much time. He is asking for probation and to do treatment, that therefore the recommendation is provided from probation as such.
All right.
I also have a ticket to deal with on the 5th, I believe, as well, but that
On Wednesday? Before me?
I think so. On June 5th, I think it is.
What's the ticket for?
Give false information to a police officer.
I don't think our PD represents you on that.
And that is correct, Your Honor.
Yeah.
Okay.
Okay, who represents you on your circuit court matters?
Judge Feaster.
Torshio Feaster.
He's in good hands. He's in good hands. Wait, don't lie. You're in good hands with Torshio.
Yeah, no, you are.
The judge will attest to that.
We've just been seeing you all over the news lately, so it's an honor to be here today.
I got that video's gone viral. I mean,
And
it's just,
CMC as well last night. Oh boy. I promise not to take your signature to eBay.
That's the first time I heard. Yeah, I haven't heard that one before, but okay. Mental note, don't sign anything. All right. Okay, sir.
Sorry.
No, you're good. Anything you want to tell the court before I oppose that?
Yes. I mean, due to consideration, I pled no contest. I just truly believe that, when I was with home and new vision, I made quite a bit of progress in my recovery for the first time ever. And I see where I made my mistakes, my recovery, what I shouldn't have done. And my sponsor, he wanted me to come down to Tennessee and be with him, but due to the consideration that I really believe I needed to continue the structure, eyes on me that, it'd be healthy for me to stay here. I do have a decent relationship in the recovery community here. And again, I did make progress, but I see where I made my mistakes at. It's no one's fault. I put myself in danger in my recovery. Get what I'm saying? So with that, I'm thankful that that my agent, she recognized, she listened to what I had to say.
Miss Valera?
Yes. And instead of
She listened to you?
Yeah.
I'm shocked. Go ahead.
Instead of just taking the easy way out, of doing the time, I felt that it was necessary to keep the structure. Bless you.
Wow. I mean, God bless you.
I felt the need that keeping that structure did helped a lot, and I was hoping that you take into consideration that I would do the Dawn Farms program in jail and be released to a treatment again to home and new vision. They provided everything I need.
I think he believes that if he gets sentenced today to that, he will move up on the list and he'll get into Dawn Farms a lot quicker.
And I would, as well as hoping you could put me on the list for Dawn Farms.
So you can get, okay. All right. And, okay. And I get it, Mr. Burlett, because what you did is, I guess with everything else pending, knowing what your sentence is in circuit, that you probably could have just said, just sentence me to time and then I'll just be done. And the very fact that you wanted probation says something about you and where you want to go. So let's see if we can try to get you there. Okay. On the DB second charge, place you on probation for a period of 24 months. You are to pay $655 fines and court costs, $720 probation oversight fees. I'm going to indicate as arranged by probation. I understand the request that you made, Mr. Kellewald. But I'm just going to indicate that's to be arranged by probation. Ms. Clara, I don't have any issue with coming to the court. And once he's out, as he maintains his sobriety, lessening it over time. So you can earn your way out of those monies. How about that?
Yes, sir.
All right.
Also with Home and Vision, when they provide the counseling stuff, they also provide drug testing. I already told her I will sign everything off so that way she will get information with no problems.
I have no problem. I have no doubt that you're going to cooperate with us. Because you know what happens if you don't cooperate with me, right?
See you back and hopefully not on Fox News with you.
Man. No, it's okay. No, I deserved that. I deserved it.
Anyways.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. Complete residential substance abuse treatment, including all aftercare recommendations with status reports to probation. You're to complete a mental health assessment, follow all treatment recommendations, including medication protocol. There's to be no contact with Jessica Rohan or Jennifer Johnson, directly or indirectly. No going to the residence or employment of those individuals. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to report to probation as requested by probation, including any home visits. You're to comply with all circuit court orders. So the review hearing, that's to be held September 9th, 2024 at 1 p.m. I'll order 365 days in jail, credit 49 served. You remain in custody until direct release to residential treatment, and then the balance is suspended. I'll do it on the other two then, I think. So that's on that kind. On count two, $50 statutory fees, 93 days in jail, credit 49 days served, defendant to serve the balance, defendant as part of that sentence to defendant to complete in jail Dawn Farm program. On count three, the malicious destruction of building less than $250 statutory fee, 93 days in jail, credit 49, defendant to serve the balance, and also on that count, defendant to serve the in jail or to complete the in jail Dawn Farm program.
Judge, just a couple points of clarification. It sounds to me on count 1, on 2, and 3 that if he completes probation or is doing well, the probation department has discretion for fines and costs.
What I'm indicating is that, and how I've done it sometimes with certain people, and this seems like a good candidate, that as he continues his sobriety, we will be looking at waiving some of those fines and court costs so that that doesn't become clearly an impediment for him.
Okay, and the last question is on number 15. Okay, he's got to serve 49 days, credit 49 days. It says to be released to treatment, but on counts 2 and 3, you want him to complete I assume that's correct, the jail sentence, so he can do the in-dawn jail program
I want him to do the in jail Dawn Farm program.
The class.
prior to the
Right,
release.
and then he can still be released. We can work all of that out, but he wanted to get up on the list to be able to do that.
Do
Right.
the class, and then once the class is complete, then
There's
afterwards I would be released.
correct.
Okay, tell me that later, then I'll write it down. Thanks, Judge. I appreciate it.
No, he
No.
understood what we were
So
doing.
I understood it.
It's okay, Mr. Kellogg. That's what happens when you show up late.
Okay.
It's hard.
You have a nice day.
Thank you. 14A stands in recess.
In this sentencing hearing, the court reviews the defendant's case after confirming that the presentence investigation report has been discussed with counsel and contains no corrections. Defense counsel emphasizes the defendant's indigency and requests consideration regarding fines and costs, noting that the defendant is also facing circuit court matters, including a recommended 1-year sentence with credit for time served and participation in the Dawn Farm treatment program, which has not yet begun. Probation confirms the defendant has a probation violation pending in circuit court, but acknowledges significant jail credit and supports a treatment-focused resolution rather than additional incarceration. The defendant personally addresses the court, accepting responsibility for past mistakes, explaining his progress in recovery through structured programs, and expressing a strong desire to remain in the local recovery community rather than relocating out of state. He highlights the importance of accountability, supervision, and continued treatment, requesting placement in the Dawn Farm program and release to residential treatment once eligible. The judge recognizes the defendant's sincerity, noting that his request for probation, despite the possibility of simply serving time, demonstrates a genuine commitment to change. The court imposes a structured sentence emphasizing rehabilitation, 24 months of probation, specified fines and costs subject to future reduction based on compliance, completion of residential substance abuse treatment and aftercare, mental health, evaluation and treatment, domestic violence programming, strict sobriety conditions, random testing, weapons prohibition, and no contact orders. The defendant is ordered to remain in custody until direct release to residential treatment, with jail credit applied and the remaining jail sentence suspended contingent on compliance. Additional counts include statutory fees and completion of the in-jail Dawn Farm program prior to release. The judge clarifies that continued sobriety and compliance may result in reduced financial obligations and sets a future review hearing to monitor progress. The court concludes by reinforcing that cooperation, honesty, and accountability will determine whether the defendant successfully moves forward in recovery or returns to court for further consequences. For more information, like and subscribe my channel.
And where are we on this? There was the hot water, the mailbox key.
I fixed the hot water.
Pardon?
Hot water is fixed.
Okay.
No mailbox key though.
You still don't have a mailbox.
They haven't reached out to me as well. I reached out to them, got no response. So I paid the $1,028 again.
1,028. Okay. You paid that directly to them,
I paid that on,
to the landlord.
yeah,
On the
straight to them.
24th. Is that correct? Okay. So what's our balance at this point?
$2,654.
$2,654. And then I have June clicking in tomorrow. So
I haven't said anything.
what's your monthly rent for?
1,028.
That's right. That's how we set that number. Okay. Okay, so this will keep us at the 20. We came down, but when could the June rent be paid? Do you know?
I don't know. I've been paying them almost every week. I can't afford to keep paying 1,028 twice a month.
No, okay, I got you. But so tell me what you can do. Because here's what I'm going to do likely, because you got to get a mailbox key. I'm going to put it out to the 14th. Okay.
Okay.
So what I guess I really was asking, between now and the 14th, what can be paid? Let's do it that way.
I can pay 500
500.
until I get paid on the 7th.
So 500 on the 7th.
Mhm.
Okay. So I'll put 500 on the 7th. That'll work. I mean,
I could pay the whole thing, but I'm just refusing to at this point. They're not willing to reach out.
Why?
I'm
You know
just-
what? She could have just let it slide.
I know I
And
can't.
I would have just let it just go. Like, all she's got is
This is-
500. Well, no, I could pay the whole thing, but.
But I'm not. But I've reached out to them several times about just, if you get the late fees off, I'd pay it in one
All right,
month.
listen, just
They
listen.
don't want
Oh,
to. Sorry.
no, I'm just gonna let you talk.
Thank you.
You ain't gonna let me.
Plus I walked here.
You want to?
I walked here. So,
Okay, so here's the deal.
okay.
Get the 500 in. Can you? Is 1,000? Let me ask you, can you do 528.
I can even go, yeah.
Okay. I want to keep the numbers where I can. Okay, so pay the 528, so it's five, I get your point. I mean, I make fun of it, but I get your point.
Yeah.
Okay. And so then I will adjourn this out to the 14th. Can we get our mailbox key?
Yes, Your Honor. Yes. And then Ms. Hobbs, you're contesting late fees or asking for a waiver of late fees. What amount of late fees? Like what amount?
They weren't, she just told me the late fees were out of the question to waive. So I haven't heard from her since then. So I'm just trying to figure out a fair amount where I can, because I can,
She said to you what?
that she wasn't waiving. They don't waive late fees, just go to court, is what she told me. And
So I have to.
absolutely, on the court.
So, but with that being said, what amount are you asking for? Do you have an amount that you're asking for?
Not really, because I just got the ledger. like
You
yesterday.
just, correct me if I'm wrong.
Okay,
She is looking, really what she's saying, at least what I'm understanding is, I ask you to do certain things, you guys really aren't doing it, you're not paying attention to me. The only way I can get your attention is not paying. And so then when I finally get your attention, you want me to do that plus the late fees. So whatever late fees accumulated during that period, I'm trying to get your attention. I don't think I should pay because all I'm really trying to do is get your attention. Is that just another way of saying it?
oh, great.
Yeah.
You go viral for this moment too. Perfect moment. Perfect.
Yeah, I'm just gonna be known as like the Ebony House Whisperer.
I swear.
All right, so that, and thank you for saying that, I guess, ma'am. All right, so with that in mind, I think council can look at it, maybe talk to Ms. Hobbs at some point in between and see if some resolution regarding that can come up. And then maybe we can just get this resolved so that Ms. Hobbs,
That's all I
Ms.
wanted.
Hobbs doesn't have to walk up here and
I do.
let me know that she walked uphill both ways.
I did.
All right.
Our phone number, our office phone number is on paperwork that you received under James Fink.
Okay.
If you want to call that, once you look at the ledger, if you want to call that, make any sort of offer, then I can present it to my client and I'll communicate with them about the mailbox issue.
That's fine.
Thank you.
Okay, June 14th, 2024 at
3 p.m.
3 p.m. Okay,
Awesome. Thank you.
all right. Have a nice walk back.
I
I got, and I gotta say, you're better than me, because I would have stopped halfway and just said, I ain't. Not realizing that if I walked halfway back, I would have been here, but anyway.
My job is like less than 5 miles away, so not bad.
5 miles?
I'm right off highway, so it's not that far.
5 miles.
Yeah. This is nothing.
5 miles, walking 5 miles.
It's nothing.
Okay.
Have a good one.
You know what?
Gotta wrap up.
If I had a job 5 miles away that I had to walk to, you know what they'd call me? Unemployed. Z.
In this housing court hearing, the judge reviews the status of an ongoing landlord-tenant dispute involving unpaid rent, unresolved maintenance issues, and disputed late fees. The tenant confirms that the hot water problem has finally been fixed, but states that she still has not received a mailbox key despite repeated attempts to contact the landlord. She explains that she continues to make payments directly to the landlord and recently paid an additional amount, reducing the balance to approximately $2,654, though she notes that June rent is about to become due. The tenant clarifies that, while she has been making frequent partial payments, she cannot afford to continue paying the full monthly rent twice a month and is seeking a more manageable payment plan. The judge asks what she can realistically pay before the next court date, and the tenant proposes a partial payment, explaining that her refusal to pay the full balance immediately is not due to inability but frustration with the landlords. Lack of responsiveness, particularly regarding the mailbox key and accumulated late fees. She argues that withholding Full payment was the only way she could get the landlord's attention and questions the fairness of being charged late fees during that period. The judge acknowledges her explanation and reframes the issue as a dispute over accountability on both sides, emphasizing the importance of resolving outstanding communication failures rather than allowing the matter to escalate further. The court sets a short adjournment to allow time for partial payment, directs that a payment of approximately $528 be made to keep the balance stable, and stresses that the mailbox key must be addressed. The judge encourages counsel to communicate with the landlord about a possible resolution regarding late fees and advises the tenant to formally review the ledger and submit any proposed settlement through counsel rather than withholding payments. The hearing concludes with the case adjourned to June 14, 2024, with the court expressing a clear preference for resolving the matter cooperatively so the tenant does not have to repeatedly return to court, reinforcing that consistent payments, clear communication, and landlord compliance with basic obligations are essential to bringing the dispute to an end. For more information, like and subscribe my channel.
Angela Cater.
Are you gonna yell at me?
I promise I won't.
Oh, okay, all right. I just have to kind of check after
No,
today.
sir.
All right. Let's see. She was gonna pay $2,400 on the 19th. Right? No, that was back in
That was back in April.
April.
Yes, sir.
That's right. All right, where are we? How much is owed?
So,
Oh, sorry, Your
No, no.
Honor, first, I don't think our office received a copy of the motion that was filed. I have that there's still $4,867.59 remaining on the judgment, and there is a total amount due at this point of $7,030.99.
All right, what do you want to say, Miss?
and I put 2,100 in escrow.
She is correct.
And so the remaining balance, I just was hoping I can get some time, due to my unforeseen medical condition with me having surgery and everything that put me back. So I go back to work Monday and I will be able to get my balance caught up, by June 28th at the latest. But with me going back to work Monday, I'm a nurse, so I can make my hours up
Got it.
and I can get my
Okay.
money.
Oh,
This is-
so you just have to get the shifts in and do
Yes.
whatever, and I
Yes.
got you. So, so I've got the 2,100, so I'm at about a $5,000, a little under 5,000 range. They were at the 4, whatever. So let me ask you this, you go back to work
Monday, yes.
So when would the next time you could deposit funds?
I can actually make a deposit on Friday, the 7th.
Okay.
I could
How
probably
much?
put $1,000 that day,
How much?
1,000.
1,000? Okay. On the 7th. Okay, so let's do this. And do you get paid every week or every other week?
Every week, because I have a part-time job. So my full-time job, I get paid one week, part-time job, I get paid the following.
She is smart. Okay, so if you pay the 1,000 on the 7th,
Mhm.
is there an amount you could pay on the 14th? or
Yes, it is.
How much?
2,000.
Go ahead, girl.
Listen, I got 3 kids. I gotta make money.
Okay. So if you can get that 2,000, are you gonna pay it into the court? Is that what you want?
Whichever way you guys tell me to pay it, I'll pay it.
Why don't you pay it into the court? That way
Okay.
I know what's there.
Okay,
Okay, so pay the 1,000 on the 7th, 2,000 on the 14th. I'm going to adjourn this to April, listen to me. June. No, they wrote July, June 14th,
okay,
2024 at 3. What time? 3 p.m.?
okay.
Okay, so if you get that in there, then we have record of it. We'll know exactly where it is. And then if that happens, well, you have the 7,030, but that doesn't include June rent. How much is your monthly rent?
$20.99.
$20.99. Okay. All right. So here's what I'm looking at. let's do this for right now.
Okay.
She's back to work. It seems like, and she's got the other job and everything. So even if it looks to me like we can probably get this maybe resolved before the end of June, but if not, we're still going to be so close going into July that we can make it work.
Okay.
Is that fair enough?
Yes, sir.
Does that help you relax
Yes,
a little?
yes, sir.
All
'Cause I
right.
was so dang on nervous. Then I saw your viral TikTok thing and I said, here we go. I got scared. Being honest.
You know,
That was,
I don't even have anything to say.
I'm
but-
saying for you, that was the dumbest he could have ever did in his life. But go ahead.
What now?
That was the dumbest move he could have ever made in his life.
I have no comment. All right.
Okay.
So we'll do it that way. Get what effectively is 3,000 in before the 14th.
Yes, sir.
We'll come back. We'll figure out where we are number wise, and then we'll go from there.
Okay.
All right.
Perfect. Thank you.
Take care.
You too.
Have a
Thank
great
you.
weekend. Mr. Fink. On the Brittany Berkey matter, Miss, let me say a number of things for the record. Miss Berkey has come to the court. She has requested an accommodation, one of which, for the most part, this court cannot do and won't. And that is that she wishes that the court close the entirety of the courtroom, inclusive of all spectators. She did not want to appear via Zoom because it was being broadcast. She also did not want other people in the Zoom room. That could not. The court, in an attempt to find an accommodation, said that, and it was improperly stated as a private hearing, but it would be a hearing that may not be broadcast. That's fine, so we could get our matter concluded. We're going to do that, although reluctantly. But then indicated that wasn't sufficient. So at that point, I instructed my staff to tell Ms. Berkey to come down to the courthouse. What has been described to me, I guess, as a disruption has occurred. She is presumably outside the courtroom. I instructed my bailiff to inform her that the courtroom is open, that I would not be removing spectators from the courtroom, and that she would have to make a choice as to whether or not she wanted to enter the courtroom. I think what she indicated is she would come into the courtroom, but did not want anybody else in here. That was her answer. That is unacceptable. The courtrooms belong to the people. People can see what happens in the courtroom. So, given that, it seems to me that my choices are to adjourn the matter or to issue a default if she refuses to come into the courtroom. I won't ask you for your input on that quite yet. I will ask Mr. Allen to step out, tell her once again that I am not closing the courtroom, and that she can make her decision as to whether to come in. Mr. Allen, if you would do that.
In this courtroom proceeding, the judge reviews two separate matters, beginning with a housing judgment involving a tenant who is significantly behind on rent due to medical issues and a temporary inability to work. The court confirms that although the tenant had previously planned to pay a large lump sum, circumstances changed after surgery, leaving a remaining judgment balance of approximately $4,875, with additional court-related amounts bringing the total higher. The tenant explains that she has returned to work as a nurse and holds a second part-time job, allowing her to receive weekly income, and assures the court she can now steadily reduce the balance. After carefully questioning her payment ability, the judge structures a payment plan requiring a $1,000 payment by June 7th and an additional $2,000 by June 14th, both to be paid directly into the court so the payments are formally recorded. The judge notes that while June rent is not yet included in the judgment total, the progress being made puts the case close to full resolution by the end of June or early July, easing the court's concern. The judge adjourns the matter to June 14, 2024, expressing confidence that the tenant's return to work and consistent payments can resolve the dispute without further enforcement action. The hearing then shifts to a separate case involving a party who requested extensive courtroom accommodations, including closing the courtroom to the public and limiting virtual access, which the judge firmly rejects. The judge emphasizes that courtrooms are public spaces that belong to the people and that transparency is fundamental to the justice system. Despite attempts to compromise by offering a non-broadcast hearing, the individual refused to proceed, unless all spectators were removed, which the court deems unacceptable. The judge explains that the only options remaining are either proceeding in open court or facing adjournment or default if the individual refuses to enter the courtroom. The judge instructs court staff to inform the individual once more that the courtroom will remain open and that the decision to participate rests solely with her, reinforcing the principle that personal discomfort does not override public access to judicial proceedings. For more information, like and subscribe my channel, *.